In January 2012, the Prime Minister's expert panel on the recognition of Aboriginal and Torres Strait Islander peoples in the Constitution handed its final report to the Prime Minister. This expert panel had been established in 2011. The panel was established because of the hung parliament in 2010, and the Greens and the independent Rob Oakeshott held Julia Gillard to an agreement that she would finally move on the 3 decades of advocacy by both the state and by Indigenous peoples for more recognition of Aboriginal and Torres Strait Islander people in the Australian Constitution. The expert panel was constituted by quite a broad group of people from across the Australian political and social spectrums. It included Indigenous leaders as well as non-Indigenous leaders. It included politicians, so representatives from the Liberal Party, the Labor Party, the Greens and the Independents, and had representatives from organisations such as the Business Council of Australia and the Law Council of Australia, and Indigenous leaders such as Pat Dodson, Marcia Langton and Noel Pearson, and I was also a member of the panel. The task of the expert panel was to address this notion of recognition in the Australian Constitution. And in doing that, the panel decided that there were essentially 2 elements we needed to look at. The first was to address the outdated notion of race in the Australian Constitution, and the second one was to insert some recognition of Aboriginal and Torres Strait Islander peoples, their culture, their heritage and their languages. So the 5 recommendations that the panel made were, first, that Section 25 be repealed. Section 25 essentially recognises that the states can ban a people of any race from voting. The second recommendation was for the repeal of Section 5126. This provision in the Constitution permits the federal parliament to discriminate against a people of any race. The last 3 recommendations were for the insertion of new provisions in the Constitution. So the first is for the insertion of a new head of power for the Commonwealth to make laws for Aboriginal and Torres Strait Islander peoples. But the importance of this section, Section 51A, is that it provides recognition. So recognition of the continuing cultures of Aboriginal and Torres Strait Islander peoples. The 4th recommendation is for a non-discrimination clause. So this is a racial equality commitment in the Constitution, and what it does is prevents a federal parliament from passing discriminatory laws. And the final recommendation is a declaratory recommendation, which essentially recognises that Aboriginal and Torres Strait Islander languages are an important part of the Australian nation. The Australian Constitution that was enacted in 1901, it expressly excluded Aboriginal people from the powers of the federal parliament. So one of the significant aspects of the 1967 referendum was that it gave the federal parliament powers to make laws for Aboriginal people. Part of the reason that Aboriginal people were expressly excluded from the powers of the federal parliament in 1901 was that they were thought to be a dying race. So what do these changes to the Australian Constitution mean for Aboriginal and Torres Strait Islander people and the Australian people? Well, really what it does is address the historical legacy of racial discrimination in Australia and contemporary racial discrimination. So what it is a joint commitment by all Australians to racial equality. And to that extent, I think it will contribute to reconciliation in Australia.